Companies Act 2013 Preliminary for Departmental Exam, In-Service Exams, PSC Exams, UPSC Exams, UGC NET Exam, Degree PG Level Exams and various other exams. Chapter 1 of the Companies Act 2003 consisting of sections 1 and 2. Company means a company incorporated under this law, under any previous company law. Section 2, subsection 20. A company is an artificial person. It has no physical existence. It is invisible and intangible. It exists only in contemplation of law. A company is an artificial person created by law having identity and perpetual succession. Artificial person. A company is not a natural person. Consequently, a company cannot fall ill or die or declared as insolvent. A company is not a natural person. Consequently, a company cannot fall ill or die or declared as insolvent. A company is an artificial person, but it is not a fictitious person. A company does exist, but only in the eyes of the law. In other words, a company exists only in contemplation of law. A company is a separate person having its own rights and obligations. Death, insolvency, insanity, etc. of any member does not affect the continuity of the company. Thus, the life of the company does not depend upon the life of its members. It is generally said that members may come and go, but the company goes on forever. Thus, a company never dies. Limited liability. Nature of company. Company limited by shares. Extent of liability of members. Amount unpaid on the shares held by every member. Company limited by guarantee. Nature of company. Company limited by guarantee. Extent of liability of members. Amount guaranteed by every member. Nature of company. Company limited by guarantee and having share capital. Extent of liability of members. Aggregate of amount unpaid on the shares held by a member and the amount guaranteed by him. The nature of company. Unlimited company. Extent of liability of members. Every member is liable to contribute to the asset of the company until all the debts of the company are paid in full. A company may have a common seal. Common seal is the official signature of the company. Shares are movable property. Section 44. Shares are movable property. Section 44. Shares are transferable in the manner provided in articles. Section 44. In private company, the right to transfer the share is restricted. In public company, the shares are freely transferable. Capacity to sue and be sued. A company can sue others and be sued in its own name. Then meaning. A company is a legal entity separate from its members. It is known by its own name, has rights and liabilities of its own. Meaning of corporate veil. By fiction of law, a company is seen as distinct entity, yet in reality it is an association of persons who are in fact the beneficial owners of all the corporate property. This fiction is created by a fictional veil, that is the corporate veil. In simple words, because of corporate veil, a company is seen as an entity separate from its members and directors. Meaning of lifting or piercing the corporate veil. Lifting of corporate veil means ignoring the separate identity of a company. Lifting of corporate veil means disregarding the corporate personality and looking behind the real persons who are in the control of the company and making them liable for the wrongs done in the name of the company. Lifting of corporate veil is also termed as piercing the corporate veil. Lifting is permissible only in exceptional cases. Lifting of corporate veil is permissible only if it is permitted by the statute or there is a clear evidence of abuse of the device of incorporation. The court has the discretion whether or not to lift the corporate veil. It is not possible to lay down a specific set of circumstances in which corporate veil may be lifted. Then, kinds of companies. Kinds of companies. Classification of companies. Section 2. Size of company. Private company. Section 2, subsection 68. Public company. Section 2, subsection 71. A private company may be one-person company. Section 2, subsection 62. Small company. Section 2, subsection 85. Other than one-person company and small company. I repeat, size of the company. A private company, section 2, subsection 68. Section B, private company, section 2, subsection 71. Section 2, subsection 71. A private company may be one-person company, section 2, subsection 62. 2, small company, section 2, subsection 85. 3, other than one-person company and small company. Liability of a company. A, limited company. B, unlimited company. Unlimited company, section 2, subsection 92. A company in which the liability of members is limited is termed as limited company. A limited company may be 1, company limited by guarantee, section 2, subsection 21. 2, company limited by shares, section 2, subsection 22. A company in which the liability of members is limited is termed as unlimited company. A company in which the liability of members is unlimited is termed as unlimited company. Section 2, subsection 92. Section 2, subsection 92. Control. Control. A, holding company, section 2, subsection 46. B, subsidiary company, section 2, subsection 87. C, associate company, section 2, subsection 6. Listing of securities on the stock exchange. 1, listed company, section 2, subsection 52. 2, unlisted company. Other companies. 1, foreign company, section 2, subsection 42. 2, government company, section 2, subsection 45. Section 2, subsection 45. 3, companies with charitable objects are non-profit companies, section 8. Then private company, section 2, subsection 68. Section 2, subsection 68. 68. Definition. Private company means a company having such minimum paid up share capital as may be prescribed and which by its articles A, restrict the right to transfer its shares. B, except in case of OPC, limits the number of its members to 200, provided that where 2 or more persons hold 1 or more shares in a company jointly, for the purpose of this clause, be treated as a single member. Provided that person who are in the one person who are in the employment of the company and B, person who having been formerly in the employment of the company were members the company while in that employment and have continued to be members after the company ceased, shall not be included in the number of members And 3. Prohibits any invitation to the public to subscribe for any securities of the company. I repeat, 3. Prohibits any invitation to the public to subscribe for any securities of the company. Then public company, section 2, subsection 71. Public company means a company which, 1. is not a private company, and 2. has such minimum paid up capital as may be prescribed. Provided that a company which is a subsidiary of a company not being a private company shall be deemed to be a private company for the purpose of this act, even where such subsidiary company continues to be a private company in its article. Definition of public company. Public company means a company which is not a private company. Public company means a company which is a private company, public company means a company which is a private company, which is a subsidiary of company which is not a private company. In other words, subsidiary of a public company is always a public company. C. Every public company shall have such minimum paid up share capital as may be prescribed by CG. Public Company, section 2, subsection 71. OPC, one person company, section 2, subsection 62. One person company means a company which has only one person as member. OPC is also a private company. In case of OPC, the words one person company shall be mentioned in brackets below the name. Every private company shall have a minimum of 2 members. However, OPC shall have 1 member only. The number of members shall not exceed 200 in case of private company. However, OPC have 1 member. OPC shall have 1 member only. Every private company shall have a minimum of 2 directors. However, every OPC shall have minimum of 1 director. Then small company, section 2, subsection 85. A company shall be small company only if it satisfies both of the following conditions. 1. Its paid up share capital does not exceed rupees 50 lakh or such higher amount as may be prescribed, which shall not be more than 10 crores. Prescribed amount of this purpose is rupees 4 crore. Okay. Then 2, its turnover as per profit and loss account for the immediately preceding financial year does not exceed rupees 2 crore. Such higher amount as may be prescribed, which shall not be more than rupees 100 crore. Prescribed amount for this purpose is 40 crore. A company shall not be a small company if it is a public company. A company shall not be a small company if it is a public company, it is a holding company of any company, it is a subsidiary company of any company, it is a company registered under section 8, and it is a company or a body corporate governed by any special act. Classification of companies based on liability. Section 2. Company limited by shares. Section 2, subsection 22. Company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. Company limited by guarantee. Section 2, subsection 21. Company limited by guarantee means a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. Unlimited company, section 2, subsection 92. Unlimited company means a company not having any limited on the Unlimited company means a company not having any limit on the Unlimited company means a company not having any limit on the liability of its members. I repeat, unlimited company. Unlimited company. Unlimited company section 2 subsection 92. Unlimited company means a company not having any limit on the liability of members. Holding and subsidiary companies. Section 2 subsection 46 and section 2 subsection 87. Provisions contained in the Act. Definition of holding company. Holding company Definition of holding company. Holding company in relation to one or more other companies means holding company and subsidiary companies. Section 2 subsection 46 and section 2 subsection 87. Holding company in relation to one or more other companies means a company of which such companies are subsidiary companies. Examples. Explanation. For the purpose of this clause, the expression company includes any body corporate. Section 2 subsection 46. Subsidiary company or subsidiary. Subsidiary company or subsidiary in relation to any other company. That is to say, the holding company means a company in which the following holding company controls the composition of the board or directors or more, exercise or controls more than one half of the total voting power either at its own or together with one or more of its subsidiary companies. Section 2 subsection 87. Then companies based on listing of its shares. Companies based on listing of its shares. Section 2 subsection 52. Section 2 subsection 52. Listed company means a company which has any of its securities listed on any recognized stock exchange, provided that such a class of companies which have listed or intend to list such a class of securities as may be prescribed in consultation with the SEBI shall not be considered as listed companies. Associate company. Section 2 subsection 6. Section 2 subsection 6 associate company. Definition of associate company. Associate company in relation to another company means a company in which that other company has a significant influence but which is not a subsidiary company of the company having such influence and includes a joint venture company. Significant influence. For the purpose of section 2 subsection 6, the expression significant influence means control of at least 20% of total voting power or control of or participation in business decisions under an agreement. Definition of joint venture. For the purpose of section 2 subsection 6, the expression joint venture means for the purpose of section 2 subsection 6, the expression joint venture means a joint arrangement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement. Then government company. Section 2 subsection 45. Government company means any company in which not less than 51% of the paid up share capital is held by the central government or by the state government or jointly by the central government and any state government. Then government company is a subsidiary of the government company. Government company is a subsidiary of a government company. Explanation. For the purpose of section 2 subsection 45, the term paid up share capital shall be constructed a total voting power where share in differential voting rights have been issued. Government company, section 2, subsection 45. Body corporate or corporation, section 2, subsection 11. Section 2, subsection 11. Generally, the term body corporate or corporation means an association of persons having the following characteristics. 1. It is incorporated under any law for the time being in force. 2. It has a separate legal identity. 3. It has perpetual succession. 4. It has the capacity to sue and own property in its own name, and similarly it can be sued in its own name. Definition of body corporate, section 2, subsection 11. Body corporate or corporation includes a company incorporated outside India but does not include a cooperative society registered under any law relating to cooperative societies and any other body corporate not being a company as defined in this act, which CG may by notification specify in this behalf. Then dormant company, section 455. Section 455. A company may make an application to the registrar so as to obtain the status of a dormant company in the following two cases. 1. It was formed and registered under the Companies Act 2013 for a future project or to hold an asset or intellectual property, and it has no significant accounting transaction. It is an inactive company. The application shall be made to the registrar in such manner as may be prescribed. Inactive company means a company which has not been carrying on any business or operation. A company which has not made any significant accounting transaction during the last 2 financial years. A company which has not filed financial statements and annual returns during the last 2 financial years. Provisions relating to nithis and its application, etc. Section 406. 406. Nithi or Mutual Benefit Society means a company with CG may, by notification in the official gazette, declare to be Nithi or Mutual Benefit Society. Nithi means a company which has been incorporated as Nithi with the object of cultivating the habit of thrift and saving amongst its members, receiving deposit from and lending to its members only for their mutual benefit, and which complies with such rules as are prescribed by CG for regulation of such class of companies. Company a citizen. A company is not a citizen. Citizenship under the Citizenship Act is available only to an individual. Therefore, no company can be a citizen of India. No rights of citizen. A company has other fundamental rights. The Constitution of India grants certain fundamental rights to every person, whether a citizen or not. Thus, a company registered in India can enjoy all the fundamental rights which are available to all persons. Thus, a company registered in India can enjoy all the fundamental rights which are available to all persons. Then definitions, section 2. Section 2, subsection 1. Abridged prospectus. Abridged prospectus means a memorandum containing such salient features of a prospectus as may be specified by the Securities and Exchange Board by making regulations in this behalf. Section 2, subsection 2. Accounting standards. Section 2, subsection 2. Accounting standards. Accounting standards means the standards of accounting or any addendum thereto for companies or class of companies referred to in section 133. Section 2, subsection 3. Alter or alteration. Alter or alteration includes the making of additions, omissions, and substitutions. Section 2, subsection 4, Appellate Tribunal. Appellate Tribunal means the National Company Law Appellate Tribunal constituted under Section 410. Section 2, subsection 5, Articles. Articles means the articles of association of a company as originally framed or as altered from time to time or applied in pursuance of any previous company law or of this act. Section 2, subsection 6, Associate Company. Associate company in relation to another company means a company in which that other company has a significant influence, but which is not a subsidiary company of the company having such influence and includes a joint venture company. Section 2, subsection 7, Auditing Standards. Auditing standards means the standards of auditing or any addendum thereto for companies or class of companies referred to in subsection 10 of section 143. Section 2, subsection 8, Authorized capital or nominal capital. Authorized capital or nominal capital means such capital as is authorized by the memorandum of the company to be the maximum amount of share capital of the company. Section 2, subsection 9, Banking Company. Banking company means a company as defined in clause C of section 5 of the Banking Regulation Act 1949. Section 2, subsection 10, Board of Directors or Board. Board of Directors or Board in relation to a company means the collective body of the directors of the company. Section 2, subsection 11, Body Corporate or Corporation. Body corporate or corporation includes a company incorporated outside India but not include a cooperative society registered. Body corporate or corporation includes a company incorporated outside India but does not include a corporate society registered under any law relating to Cooperative Societies Act, to any other body corporate not being a company as defined in this act, which may by notification specify in this behalf. Section 2, subsection 12, Book and Paper and Book or Paper. Book and paper and book or paper includes books of accounts, deeds, vouchers, writing documents, minutes, and registers maintained on paper or in electronic form. Section 2, subsection 13, Books of Accounts. Books of account includes records maintained in respect of all sums of money received and expended by a company and matters in relation to which the receipts and expenditure take place, and to all sales and purchase of goods and services by the company. 3. The assets and liabilities of the company, and the items of cost as may be prescribed under section 148 in the case of a company which belongs to any class of companies specified under that section. Section 2, subsection 14, Branch Office. Branch office in relation to company means any establishment described as such by company. Section 2, subsection 15, Called up capital. Called up capital means such a part of the capital which has been called for payment. Called up capital means such a part of the capital which has been called for payment. Section 2, subsection 16, Charge. Charge means an interest or lien created on the property or assets of a company or any its undertakings or both as security and includes a mortgage. Section 2, subsection 17. Section 2, subsection 17. Section 2, subsection 17. Chartered Accountant. Chartered Accountant means a chartered accountant as defined in clause B of subsection 1 of section 2 of the Chartered Accountant Act 1949 who holds a valid certification practice under subsection 1 of certain 6 of the company. Section 2, subsection 18, Chief Executive Officer. Chief Executive Officer means an officer of a company who has been designated as by it. Section 2, subsection 19, Chief Financial Officer. Chief Financial Officer means a person appointed as the Chief Financial Officer of the company. Section 2, subsection 20, Company. Company means a company incorporated under this Act or under any previous company law. Section 2, subsection 21, Company limited by guarantee. Company limited by guarantee means a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake contribute to the assets of the company in the event of its being wound up. Section 2, subsection 22, Company limited by shares. Company limited by shares means a company having the liability of its members limited by the memorandum to the amount, if any, unpaid on the shares respectively held by them. Section 2, subsection 23, Company liquidator. Company liquidator means a person appointed by the tribunal as the company liquidator in accordance with the provisions of section 275 for the winding up of a company under this Act. Section 2, subsection 24, Company Secretary or Secretary. Company Secretary or Secretary means a company secretary as defined in clause C of subsection 1 of section 2 of the Company Secretaries Act 1980. Section 2, subsection 25, Company Secretary in Practice. Company Secretary in Practice means a company secretary who is deemed to be in practice under section 2 of under subsection 2 of section 2 of the Company Secretaries Act 1980. Section 2, subsection 26, Contributory. Contributory means a person liable to contribute towards the assets of the company in the event of its being wound up. A person holding fully paid up shares in a company shall be considered as a contributory but shall have no liabilities of a contributory under the Act whilst retaining rights of such a contributory. Section 2, subsection 27, Control. Control shall include the right to appoint majority of the directors or to control the management or policy decisions exercisable by a person or persons acting individually or in concert, directly or indirectly, including any virtue of their shareholding or management rights or shareholders' agreements or voting agreements or in any other manner. Section 2, subsection 28, Cost Accountant. Cost Accountant means a cost accountant as defined in clause B of subsection 1 of section 2 of the Cost and Works Accounts Act 1959. Section 2, subsection 29, Court. Court means a high court having jurisdiction in relation to the place at which the registered office of the company concerned is situated. The district court, in case where CG has by notification empowered any district court to exercise all or any of the jurisdiction conferred upon the High Court with the scope of its jurisdiction in respect of a company whose registered office is situated in the district. The Court of Session having jurisdiction to try any offence under this Act or under any previous company law. The Special Court established under section 435. Any metropolitan magistrate or a judicial magistrate of the first class having jurisdiction to try any offence under this Act or under any previous company law. Section 2, subsection 30, Debenture. Debenture includes debenture stock, bonds or any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. Section 2, subsection 31, Deposit. Deposit includes any receipt of money by way of deposit or loan or in any other form by a company. but does not include such categories of amount as may be prescribed in consultation with the Reserve Bank of India.